essentially what the Wiretap Act prohibits is the use of, for gain, information that was obtained in violation of the law. And in other words, if you're intercepting someone's data communications and you're using those for your own gain, in a example family law case, then those communications are not only barred, but more importantly, they can be actionable, which means they can open the person who did the intercepting, the wrongful interception, to some sanctions and some liabilities arising from the wrongful interception of those transmissions and then the attempt to use those transmissions. So the Wiretap Act prohibits the collection of and recording of another person, not only in their oral communications, but also in their electronic communications. And there's exceptions to that. It doesn't apply where there's no expectation of privacy or where there's no expectation of, and these are definitions that are explained in the actual law itself, if there's no expectation that you wouldn't be recorded. But essentially what that means is you can't record and spy on each other and then thereby be rewarded for illegal conduct later by being able to use that against another individual, another citizen, for gain. And the Wiretap Act provides two different types of penalties. There's a criminal violation, which I'm sure it's not the U.S. Attorney's biggest case. Certain situations where a wiretap would be helpful might be something on a large scale, certainly industrial espionage scale, but where more commonly would affect citizens is if you've got spouses who are recording each other or recording each other without consent and knowledge, or intercepting messages. These aren't the cases that the U.S. Attorney is going to have time for unless it really creates bigger issues, but does open up the non-consenting intercepting citizen, whoever that is, the person doing the spying, to civil penalties and civil damages for intercepting illegally communications or recording illegally communications. So be cognizant of that.